Goeiedag, good day, fellow South Africans and citizens of the world.
I've been looking around for salvation. I've been looking around for the truth. All around me I see frustration, and I looked all over till I found you. I sit and listen to your stories, and you're telling me, please don't worry. There's a lot in this world you should know, and love in life is where you should go. If you're looking for somewhere to go, if you're looking for someone to know, if you're looking for someone to guide you, then love in life will guide you.
Goeienaand, good evening, fellow South Africans and citizens of the world. Well, the elephant in the room yesterday was quite clearly my vision. I'm sure you've all seen the video about what went down, and I do apologize that there wasn't a daily email sent out yesterday, but I had a shit of a day. I mean, that's all I can say. I had a shit of a day. If you have a look at my good eye, you'll see that it's not looking good, and my vision is not right, but hopefully the injection will fix that. It doesn't happen miraculously straight away. So that's the situation, and as a result, I will be not putting up as many videos or spending as much time as I have traditionally in front of the computer. So please bear with me about that. I mean, it's I can't afford to go blind, and that I had an emergency consultation with an eye expert or optometrist who gave me the injection in the eye yesterday afternoon, my time, which was this morning, South African time. Now, talking about South Africa, the big news is we are going to be covering live, we're scheduled to cover tomorrow morning from 8 a.m. live the events taking place in Groblersdal, and this is the latest cab off the rank when it comes to what's going down in Groblersdal. You can see here the economic freedom fighters are planning to gather outside the Groblersdal Magistrates Court from 4 o'clock in the morning tomorrow. Now remember, the reason why Bitterreinders, Petrosito, and General Isaac van Zyl are going to be there at the venue is because Police Minister Bekesele is expected to attend as well, following a phone call that he had with Petrosito, which I put up on Loving Life TV close to a week ago now. So this is a powder keg. You're going to have some very, very disturbing situations arising, and especially when you got Julius Malema involved in the background. So as I say, 8 o'clock tomorrow morning, we will be covering this event live. Please come and join us, and we will. I don't think Isaac and Petrus have actually met each other before, so I'm going to see if I can organize that as well during the live stream. Because Petrus has basically been given the bum's rush by people like the Bitterreinders and a couple of these so-called media identities in South Africa. And that's got to stop because he's doing such good work. All right, guys, I'm going to leave that where it is. We'll find out what happens tomorrow. I'm going to get my guest on now. That's, of course, Reyno de Beer, and we're going to be talking about a lot of stuff regarding the justice system in South Africa. So here we go. Enjoy the live stream, and here we go. Oh, that's my eye. Sorry, I hit the wrong button. Okay, let's try again. Hi, Reyno.
Yes, hello Scott, how are you?
Excellent, buddy, excellent. Except for my good old 69-year-old, or nearly 69-year-old eye. I'm in very good shape. Look, before we kick off, I've had a request in the side chat that I just want to get out the way before we get into our subject tonight. And Jakes has written, can you ask Reyno why no contact numbers are answered? 2 WhatsApp numbers, 2 emails, and also not his landlines and cell numbers. Is there a phone number that people can contact Liberty Fighters Network at to get through to you?
Well, that's strange. Well, you can contact me on my email address, and he's more than welcome to send me an email.
Okay. And can you just read it out to me, and I'll just write it out.
It's my name, Reyno, Reyno,
yeah,
at libertyfighters.co.za.
libertyfighters.co.za. So if anyone wants to contact Reyno de Beer, this is the email address. Okay, so there you go. There you go. That's the way to contact Reyno. I hope that helps, Jakes.
Well, it's strange that there is a landline.
Yeah.
So maybe he's just impatient and think that people must answer immediately. But there's usually someone that will answer.
Right.
You must just be patient and try again.
Yeah. Alrighty. Okay. Now, that's a great introduction. Let's get started. Now, Reyno, I think most people who are watching now know what Liberty Fighters Network stands for, and as people know, I'm 100% behind you. I think you're doing a fantastic job, and during COVID, you took on the system, and we know how the system basically effed around, and how the ANC ministers just took the law into their own hands and somehow came out squeaky clean. But tell people about Liberty Fighters Network. Can you provide an overview of what you do and the primary goals, etc.? Back to you.
Well, thank you, Scott. Well, we focus on empowering the man in the street with the law. We're trying to represent people as far as we can as non-legal representatives. We basically encourage people to become their own lawyers and to get rid of the legal fraternity. Those people who actually follow Liberty Fighters Network, we totally despise the legal fraternity in all its form and shapes and sizes. And we believe that the legal fraternity is the cause of most of the problems that we are actually experiencing, because they're basically the soldiers of the corrupt, which are mostly the banks.
Yeah.
So So the moment when you're a legal practitioner, and sorry for the very few, and there's literally probably only 10 of them that's actually good lawyers. Unfortunately, the moment when you become a lawyer, a legal practitioner, you basically sell your life to Satan. All the rituals and everything connected to it are indicative to actually the occult, and with the cloaks that they are wearing, and the fact that you must pray for relief, and you need to call the person in front Lord, and your honor and your worship. It's all about degrading God. So we are just there to say that people, we cannot allow the legal fraternity to rule our lives. You need to, we assist people to empower themselves with the law so that they can become their own lawyers at the end of the day. We assist people who are unable to obtain the services of a legal practitioner at the end of the day. And we are helping people without expecting anything in return. So that's basically in a nutshell that where we focus on. And obviously in the process, we do get involved in numerous of public interest matters, and we are pursuing it on our own without legal practitioners involved. So yes, that's a nutshell, Scott.
Right. Okay. Now, just on that very subject, tomorrow night at 8 p.m. I'm talking again to Emerald van Zyl, who's a forensic investigator into banks, and we're going to be basically continuing our discussion about the banks. And one of the questions I'm going to be raising with him is how the banks use retainers with legal companies, all big legal companies, so that the legal companies cannot take them to court. They cannot represent clients of the banks. That's a primary role of a retainer, and it's very common. Yeah, back to you.
That's 100% correct. So the problem is that while I've mentioned that the legal fraternity is basically the soldiers for the corrupt, mainly bank system, you will not easily, if ever, find a lawyer who's prepared or who's going to represent you against the bank and actually try to win the case for you.
Right.
The moment when you go to a lawyer, asking the lawyer, please help me with this summons I've received, just ask that lawyer whether he or she is on the roll of any bank whatsoever. Right. You cannot, the moment when a lawyer is doing work for a bank, then just pack up your stuff and run out of those offices immediately. And unfortunately, I haven't found any attorney at present who does not do work for the bank. So unfortunately, they will not bite the hand that's feeding them. And if they do assist you, they will most probably assist you in such a way that the bank is benefited by it. So whenever the bank sues you, go and defend that case yourself. You've got a much better chance of succeeding in defending your own case as you would have been if represented by a legal practitioner.
Right. Now, okay, on this very point, Reyno, you mentioned that you've been appearing in court as a self-represented litigant for over 30 years. How did you get involved in this role, and what motivates you to represent others without expecting any remuneration?
Yeah, it actually happened when I was in matric in 1994. So my mother had a dispute with a sectional title scheme body corporate, and that was the body corporate wanted my mum to get rid of our dogs. We had 2 dogs at that point in time that we previously got permission for. And yes, that was basically when I started trying to find out what the law is, and I've at that point started to get interested in law, and that basically opened the doors for my interest in law all over. I've studied it, started studying it at university, but I got so interested, fascinated by all the books in the UNISA library that I spent more time in the library than actually spending time doing my or attending to my studies. And eventually money ran out, and I couldn't continue with my law studies anymore. And so then I became involved actually in property management, and that is I eventually got qualified for as a property manager. And in property management, you get so much involved in legal matters, that you have to know the law on all aspects, from all points of view, from estate law to companies law to family and persons law of persons, everything that you get to get involved. So during those times, I've actually assisted quite a number of people with their own cases as well, and also bodies corporate and sectional title schemes, and people who have issues with their landlords, etc. And that was when I've started also to represent myself in many occasions in court, and also assisted people to do the same. So it's actually a work in progress over a period of 30 years. That has gotten me to the point where I am today, and so it's not easy. It's very difficult to represent yourself at the end of the day. But the moment when you get a hold of it, you become the nemesis of any attorney or legal practitioner out there, because what just like I despise the legal fraternity. Legal practitioners despise those individuals who know more about the law than they do. And yes, I might be arrogant in that respect, but I'm very proud of it, that I'm basically the nemesis of several legal practitioners out there over the years. But at the end of the day, through the work that we do as self-represented litigants as well, we encourage many other people to represent themselves as well. And you currently have a situation in our courts today where many people, more than they used to be before, stand up, and they know that as we teach the people that the answers are basically just a Google or DuckDuckGo away. You can do your research on the internet, go and come in contact with organizations like ourselves and others who have represented themselves before. Get the information and do your own cases. You will not only save a lot of money, but you will save a lot of grief for you as well by doing that.
Right. And of course, you've got artificial intelligence today as well, which is quite an extraordinary thing.
That's a problem because, artificial intelligence, people want artificial intelligence to be your own intelligence as well. And there have been occasions before that have been reported where legal practitioners have used artificial intelligence to create heads of argument for a case, for example, and the moment when you start argue the case, then it refers to a certain case, and when you actually go and research, you will find that that case does not even exist. So the artificial intelligence was so clever to have manufactured case law. So you have to have the background of basics of law.
Right.
You cannot just rely on artificial intelligence. It's wonderful. I also, from time to time, use artificial intelligence mainly for grammatical checks. But at the end of the day, you must have the basis and know where to get the information. And then once you've got the information, you can feed the artificial intelligence with it, and then you will get a much better result at the end of the day. But be careful for just simply relying on artificial intelligence.
Yeah. You know what freaked me out? Last year, I've only actually looked at or used artificial intelligence once or twice just for fun. And I typed in, can you construct a poem on Scott Bolson, on myself in other words? And literally within seconds it came up with a poem which is about 16 lines, and it summed me up to a T. It was absolutely creepy. I thought, jeez, this is really creepy.
Yeah.
But look,
we can talk about technology and spying and the New World Order on another occasion. So, but when it comes to the law, I do suggest and advise people that go and do the research yourself. Don't rely on artificial intelligence. The moment there are basics that you need to teach yourself, and eventually we will also start giving classes, online classes to people who's interested in representing themselves and also assisting their communities. Because at the end of the day, when you empower yourself, you can teach others in your communities to do exactly the same. And that would be so wonderful at the end of the day, where we can see more and more attorneys and other legal practitioners closing their doors. That would be great.
Right. Now, look, just while we're talking about the law, what's your take on this idea that we are actually under marine law and our name is capitalized because we're actually an entity and not actually a human being? What's your comment on all that? Because a lot of people are talking about this, and I know here in Australia a couple of people have tried it and they've landed up on their backsides very badly because the judge just tells them to, get out of his court when they start trying to pull this sort of stuff. So over to you. What's your thought about marine law?
Well, the natural law and the common law principles are wonderful, but not in a country like South Africa. Very few legal practitioners and judges and magistrates actually know the common law and natural law. So the moment when you start arguing as a living, breathing,
natural person,
female or actual person, no, don't say a person is actually a juristic persona that the government and society, the system, has allocated to you. So you need to refer to yourself within the natural law and the common law as a human being, a man and a woman.
It sounds awfully like pronouns and this LGBTQ stuff.
Oh, yeah, but that is a positive thing in the sense of how the Bible refers to you as a human being. And so the whole idea about it, and I'm just going to summarize this, is that that you basically emancipate. That's the word that they use.
Yeah.
Emancipate yourself from the current system and become totally an independent
Entity.
human being. Not entity, human being.
Okay.
But the problem is that, and this is what I've been telling people all the time, and we get more and more cases where people who have emancipated themselves are thrown under the bus, and then they lose their properties because they have not attended to the court cases. Because there are certain people out there making money out of emancipation, who are actually telling people the moment when you have filed these emancipation documentation at court, you can just go away and don't attend to that case anymore, because otherwise you are stepping back into the system. The reality is that the moment when you conducted or signed that contract with the bank, you did it within the system on their terms.
Right.
You have agreed to the system when you have entered into that agreement.
Yeah, that makes
And
sense.
what these people don't tell you, who's advocating emancipation, and you will be a clean person without any debt, they don't tell you that the moment when the bank sues you for your arrears, you cannot emancipate. Even if you emancipate yourself, that contract is still in the system which you have signed. You cannot get out of that contract by emancipating yourself. And you need to, if they are fighting on this level and you are in an emancipation area, obviously they will continue with this system in your absence. They will get judgment against you in your absence in that system. They will sell your house in that system. And you cannot do anything about it when you are emancipated and you are told not to come back into the system. You have to fight them on their terms, on their level, in their system. That's the only way. And when you know how, and you've got us, for example, as your advisors, how to do it, you will be able to use their own system against them.
Right.
Properly.
Yeah.
So unfortunately, we are sitting with, I've got so many cases which have come my way the past month or two, where people have thought and have been told that the moment when you emancipated, the bank must just write off your debt and you can keep your house and they cannot do anything. And at the end of the day, the bank does sell your property on auction. They will eventually tell you to get out of it. And if you cannot fight them in their system and you still rely that you cannot touch me because I'm emancipated, and you cannot enforce your rights whatsoever in that emancipation system, then you're going to lose your home because you have sat back and have done absolutely nothing about it. And I get so frustrated, Scott, and angry with people who make money by telling people that let us assist you with emancipation documentation, and they even tell you exactly you need to send this to the Chief Justice and to the President and to SARS and whoever, and they're making their buck. And the moment when you go back to them and tell them, but your advice to emancipate have backfired, then those people are nowhere to be found. And these poor people have literally paid their last cents of savings that they could get to those people to emancipate them. So please don't use emancipation in the way that you are told. If you are sued and you have signed a contract in the system, you need to fight it in the system. The moment when you are emancipated and you don't have any debt, and you go to a bank and you or tell them, I am emancipated, I want you to provide me with a loan, the bank will most probably, 100% sure, not give you a loan. And that is then their terms. If you don't want a contract, don't contract. But unfortunately, there are people who have, many of them have not even seen the inside of a courtroom, and then they want to advise people on such important matters like keeping their homes. It's just totally pathetic,
Yeah.
but that's also something for another day.
Yeah. Okay. Now, the Legal Practices Act of 2014 plays a significant role in your work in South Africa. Could you explain how this legislation affects your ability to represent others and the challenges it poses?
Yeah. Well, I actually like the Legal Practice Act of 2014 in the sense that Section 33 in particular has opened the door for people to represent one another with a caveat, with a condition that if you do not expect anything in return for that service, if you're not a legal practitioner. So anyone, Section 33 of the Legal Practice Act, which obviously came into operation, I think it was sometime in, I'm talking under correction, in 2016 or so. I know that there was some period from the minute when it was actually proclaimed and when it came into operation, but it came into operation sometime after it was promulgated. But in any case, the moment when it came into operation, there used to be a practice that, for example, that if you are, let me start off with in the magistrates court. In the magistrates court, there's a specific rule. I think it's Rule 52 of the magistrates court rules, which specifically indicate who may appear before the court. So in particular, it says that if you are a member of a close corporation or a director or other representative or official of a company, you are entitled to appear on behalf of the company. So the magistrates court made provision that a company, for example, could oppose or institute process in its own name, and you don't have to have an attorney doing it for you. You can use one of your officers to do it. But in the High Court, the practice was totally different. And if you are a member of a close corporation, for example, you could not automatically represent a close corporation in the High Court. You first have to bring an application, it's called a representation application, to ask permission from the court that you as a member may represent your own close corporation, even if you are the alter ego of that close corporation. That have led to a lot of questionable judgments in the past, whereby the judges just simply said, no, you are not allowed to represent your own company or your own close corporation, and then the cases continue as if it was not opposed or defended. We currently have one of those cases where that actually happened, and which is currently before the African Commission on Human and People's Rights, where we have proceeded with that specific case. But in any case, now that was how it used to be before the Legal Practice Act came into operation. So if now it stands that if you, for example, you now a member of a close corporation, if you are not specifically paid to represent the body, the close corporation, or you can even, like we also do, and which we have done successfully, Liberty Fighters Network then lodged an application to court to ask for permission in terms of Section 33 of the Legal Practice Act to represent our members, and the courts do give us that permission. And then I also go ahead and represent Legal Liberty Fighters Network, and because you are then a member of Liberty Fighters Network, I automatically also represent you in those cases. So we've done a couple of those matters where the courts have allowed us to do that, and that has actually made a big breakthrough in the law of South Africa, where in the high courts there is no such practice anymore, where you must first obtain permission to represent your close corporation, or so as it was before. It's basically automatically given that right in terms of Section 33, provided that you do not charge any money for that.
Right. Now, okay, getting on to you personally, you're currently facing contempt of court charges related to an incident with the Supreme Court of Appeal, or SCA, in June 2021. I'm sure this is related to your successful judgment from, I've forgotten what the judge's name was. It was a white fella.
Davis,
yes. That's it. Who actually approved or said that the lockdowns and the masks and all this shit were BS, and they should end. And that's when I think it was Dlamini Zuma sort of kind of was a no-show, and despite that fact, everything was cool, and the courts just let her get away with it. But then, if you stepped out of line, then this is what happened. Could you provide some details about what led to these charges? This is the contempt of court charges against you, and how the situation unfolded.
Well, that was way back in June 2020, when we obtained that order from Justice Davis declaring the COVID-19 regulations as unconstitutional and invalid. And those who can still remember, the government was given 14 days to rectify and republish those the regulations. So what happened was that the government, Dlamini Zuma, yes, but it was actually never her. It was always guided by Cyril Ramaphosa. Cyril Ramaphosa was always behind everything about COVID-19 from the beginning to the end. All those names that popped up, like Dlamini Zuma and Mkhize, the health minister, and etc., etc. At the end of the day, they were just merely puppets on the screen. They never took charge of, or could never have taken charge of those matters, even if they wanted to. But to make a long story short, the 14 days, what usually happens, Scott, is that the moment when an application for leave to appeal against a decision is filed at court, it automatically suspends the operation of the judgment.
Right.
However, the law says that the moment when there's a declaration of invalidity, constitutional invalidity, it's actually in fact regulated in terms of Section 172 of the Constitution, which basically say that the court which granted that order is the only court which can suspend the operation of the time periods and also to make decision to judgments about it. So the ordinary rule that an application for leave to appeal suspends the operation was never applicable in our case. And that specific, the reason for that is also confirmed in a constitutional court case. We just call it the New Clicks case of 2007, but where that was specifically confirmed by the constitutional court, how it operates. And so the 14 days from the date the judgment was given on the 2nd of June 2020, the 14 days lapsed on midnight, the 23rd of June 2020. So the next day, the 24th of June 2020, we had a hearing for an application for leave to appeal for the minister, for the government. So at that time, I just told the Judge Davis, sorry, why should you actually give leave to appeal if the order came into operation after midnight, the 23rd of June. So from the 24th of June, from today, it came into operation. And at that stage, the court went wild. Everyone was talking, and even Trengove was appearing for the government. He was quite shocked. He didn't expect it. Because he knew the implications of that argument I had, because he was actually the one who successfully argued the New Clicks case of 2017 before the Constitutional Court. So he knew that I was correct. He knew that. However, notwithstanding, leave to appeal was granted. But when they proceeded with the appeal, I sent a letter to the then President Maya of the Supreme Court of Appeal. President Maya is currently the Deputy Chief Justice of South Africa. So I've sent a letter to her indicating that we have to address several points, preliminary points, which I believe is vital to actually make the entire appeal process by the minister totally moot. Because the court, if the order came into operation from the 24th of June 2020, it means that there are no more COVID-19 regulations. And if the court would actually continue hearing that case, they would actually become legislators by reviving those regulations which were already invalid and not there anymore. So I wrote that letter and I never received a response for that. So basically the contempt of court charges, I will address it a bit later on, that it originated in the fact that the courts as well as the state totally disregarded the Constitution of South Africa. The Constitution specifically proved and confirmed that the COVID-19 regulations stopped in total on the 24th of June 2020. And as everyone knows, that for a further 2 years, we have been rigidly slapped over the fingers repeatedly of not conforming to those regulations, which were totally invalid and constitutional for 2 years. So that is basically the contempt of court arose from my opposition basically to the unconstitutionality of both the courts and the state itself. Scott?
sorry. Yeah, you mentioned opposing an appeal by Dr. Nkosazana Dlamini Zuma and lodging a recusal application against the 5 judges of appeal. How did this recusal application impact the virtual hearing, and what were the outcomes?
Well, what happened was that because it's just logic, and when I explained this to all of the listeners who's listening to this and who are not conversant with the law, it should be logic that the moment when the COVID-19 regulations instituted virtual hearings in our courts because of the so-called COVID-19 epidemic, or what you want to call it. Okay. So the COVID-19 regulations gave rise to virtual hearings.
Yeah.
Because the law says that a hearing is actually supposed to be heard in open court.
Right.
So what we said was that when they started with wanting us to have a virtual hearing before these 5 judges of appeal, we said that we totally refuse to attend a virtual hearing because our case is all about not conforming to the COVID-19 regulations. And if we would proceed on a virtual hearing platform, it would indicate that we agree that the COVID-19 regulations are basically still valid. And if the court would force us before a virtual hearing, that would make the court biased, because then they confirm that our success that we have already had with declaring the COVID-19 regulations as unconstitutional and invalid would then not be correct, or our position. So that would make the court biased. So in the interest of justice, this matter had to be put or enrolled before an open court in Bloemfontein. So then the communication started, and these judges allegedly decided that no, they're going to proceed with a virtual hearing. Eventually, the chief registrar of the SCA, Mrs. van der Merwe, at that point in time, she basically, the judges outsourced, listen to this, the judges outsourced their decision-making authority to Mrs. van der Merwe to determine that the hearing had to take place before a virtual hearing. So the Monday, the matter came before the judges on the 26th of May 2021. On that Monday before the Wednesday, we have lodged an application for the recusal of all the judges based on the fact that there's a reasonable apprehension that they are will be biased or are biased by forcing us to have a virtual hearing on the 26th of May before them, while they knew that we believe, and it's our position, that the COVID-19 regulations are invalid and should not be enforced anymore. So when it came to the 26th, the morning, we were forced onto a virtual hearing. We just simply said that, sorry, we cannot address the matter on a virtual hearing, and that is why the recusal application are before them, and that they first need to address the recusal application in open court before they can proceed to the rest of the hearing. So then they tried to influence me that morning to proceed virtually, but on a how did they put it, on a no prejudice basis, not to suggest in any way that we are happy with the virtual hearing. And I just simply told them all the time that you need to stop this hearing. First, enroll the matter, the recusal application, to address your recusal, and then we can determine based on that outcome whether we're going to have a virtual hearing for the remainder, yes or no. And they constantly forced me to proceed virtually, and I just said that I will not shoot myself in the foot to agree to the virtual hearing. So they eventually then excused me from as a participant, and they just declined to hear the application of recusal. And they proceeded in my absence to hear the matter. So the recusal application then, actually, as I would address soon hereafter, actually initiated the whole dilemma of the so-called contempt of court and what followed afterwards.
Yeah. Now, back then, I think Paul Myberg was the registrar of the SCA, and he sent you a letter of apology. Could you elaborate on the content of the apology and its implications for your case?
And that was another pathetic response at the end of the day, in the sense that how is it possible that the court apologizes for their own irregularities? How is it possible that the registrar sends you a letter after the hearing, which have went in the direction where I couldn't proceed with it, so it went on in my absence, only hearing the side of the government. Yes, I did file heads of argument before the time, but the heads of argument have totally been disregarded. They didn't even mention one bit of it, actually, in their so-called presumed judgment. But afterwards, Paul Myberg sent me this letter saying that he apologizes that he did not send my letter of the previous year to President Maya so that the preliminary issues could have been raised beforehand, and that Justice Maya did not know about my application because Paul Myberg did not give it to her.
Right.
So that was at that point when I totally flipped and I said, okay, I need to do this. This communication was, I think, on the 5th of June, where I received this letter from him. And then I said, okay, I need to do something about it, because this is a confirmation that the entire proceedings before the court on the 26th of May was irregular, and that I need to do everything possible to stop a judgment being granted in or issued in that respect.
Right. Okay. Now, you communicated then with the president of the SCA, Justice Mayer, now the Deputy Chief Justice, regarding the irregularities. What was the nature of this communication, and how did Justice Mayer respond to your concerns?
Okay. I've decided to lodge a formal complaint against the judges and Mr. Myberg, obviously, or against the entire SCA for that matter, with Justice Meyer in a so-called privileged, qualified privileged communication. What that basically means is that the moment when you say that this has to be dealt with only between me and you and not others, and that this is confidential and may not be shared with anyone else. So that, in terms of the law, that those communication was supposed to be protected, not to be used against me in any way. So I've lodged this complaint, only addressing it to Ms. Justice Meyer, complaining about what have happened with the judges and that they have not attended to the recusal, and then suddenly I've received this apology, which is highly irregular, from Mr. Paul Myburgh, indicating that he did not do his job, he did not send the documentation he was supposed to the judge. And Scott, eventually the judge came back, and then we've started to communicate, and then she did give a response, which was quite shocking at the end of the day.
Right. Okay. Now, Justice Mayer refused to declare the hearing invalid and directed you to wait for the judgment. How did you resort to or how did you react to this decision, and did it influence your subsequent actions?
Oh, yeah, it did. And what transpired at that point in time, after I've received an email from her saying that she will not do anything about this complaint and that I must just simply wait for the judgment, as you can imagine, I was highly upset, and I realized that there was a total collusion going on with this entire matter.
Right.
It was deliberate, it was intentional, it was corrupt. And I then proceeded with a letter on the 17th, I believe it was either the 17th or the 19th of June, which basically went in the line to only address to her in the qualified privileged communication I had with her.
Right.
That that the entire SCA may stick its virtual apology up its arse. And I've then basically concluded how they are trampling on our rights. They are making a mockery of our constitution with what they are doing, and they are not worth to be called judges at the end of the day by what they are doing, by allowing this to happen openly in the way that it happened. So Justice Meyer never did anything about that because of the fact that it was qualified privileged communication. But unfortunately, somehow, and it could never have been from Justice Meyer, and it could most probably only have occurred by Mr. Paul Myburgh himself, who have actually given that privileged documentation to the other judges. And in the judgment on the 2nd of July 2021, without addressing it with me, without addressing anything about the irregularities that occurred, etc., I was not given the opportunity for a right to be heard. They have basically made the decision that I was contemptuous, and resulting from my contempt, the matter had to be sent to the National Director of Public Prosecutions for my possible prosecution, the criminal prosecution, which the National Director of Public Prosecutions eventually instructed the Director of Public Prosecutions in Bloemfontein to institute contempt of court charges against me. And I will tell everyone how exciting or how those proceedings against me actually evolved now with my latest hearing on the 18th and the 19th of January. But yeah, I will address that in a couple of minutes.
Right. Now, you've initiated a defamation claim against the SCA in the High Court, Gauteng Division in Pretoria. And mate, I've got to say, you've got balls. I mean, you really do. You're taking on a very corrupt judicial system. But could you share the detail of this defamation claim and the response from the SCA to it?
Yeah. Well, for this is the first of its sort lawsuit in South Africa's history, whereby I have sued the Supreme Court of Appeal for defamation, specifically contained in the claimed judgment that I've just referred to, where they accused me of so-called contempt of court, and basically to the sense that they have already decided that I was contemptuous and in fact a criminal. And they could not have done that without giving me the opportunity to be heard, and also for the court to then declare it in a criminal trial process, declare me as a criminal. So after an application to the Constitutional Court, two applications where the Constitutional Court, or where I have cited the Supreme Court of Appeal as a respondent in those matters, all the respondents did not respond at all to those applications. And the Constitutional Court basically confirmed that they have read and considered my case, and that at that point in time they would not grant me direct access. So the fact that they have done it twice, they've basically confirmed that the Supreme Court of Appeal could have been a party in proceedings, as I have listed them.
Right.
So that opened the door for me to then issue in the High Court a claim for, I've literally thumb-sucked it just for entertainment purposes, basically, where I'm claiming 5 million rand in defamation damages. And I did not for 1 minute believe that the Supreme Court of Appeal would actually have entered a notice of intention to defend. But strangely, this notice of intention of defend came into my email inbox from the State Attorney's Office. And get this, the same State Attorney, Mr. Zulu, who has represented the government in the case before the Supreme Court of Appeal against me, is now the attorney of record for the Supreme Court of Appeal as well. Get that.
Wow.
Into that. That is so marvelous for a broken constitutional society, where they openly say that they are colluding. The courts and the state have become one and the same because of the fact that the Supreme Court of Appeal was supposed to be impartial and independent. They should never have defended the case in the first instance. They should have just left it, and the High Court on default judgment would have then attended to the matter eventually as it should be. But the fact that it has defended the case means that the Supreme Court of Appeal has become an entity which is capable of being sued or sue and be sued. in our society. That is not supposed to happen because of the fact that our constitution has got three constitutional pillars, namely the executive, the legislature, and also the court. And now it's clear that the court and the state have become one and the same. Undisputably, no one can deny that this is a total miscarriage of justice that is currently taking place. I have lodged an application now in the High Court to basically declare that the entering of the defense should be declared as irregular and that the Supreme Court of Appeal could never have entered a defense. So that case is going to be enrolled now. We've already filed the necessary paperwork for that application, and there was an exchange of affidavits in that process, and I need to now proceed with the enrollment. So that is going to be a very interesting court case. If I was the judiciary of South Africa, I would clearly do anything and everything in my means not for this case to be heard. So I hope that someone like the Chief Justice of South Africa would eventually call me in for a cup of coffee and ask me, Reyno, sit there, let me hear what your complaints are so that I can address it. And at that point in time, I will tell the Chief Justice exactly what I think is going on with the judiciary of South Africa and why the state can ruin our lives on a daily basis as they please, trample over our rights, and nothing is done against them because the courts do not want to act against the government, against the state anymore, because they are one and the same thing. There's a saying, Scott, that the courts do not have the power of the purse nor the power of the sword. So it basically means that the state is supposed to provide the funding for the judiciary, which is supposed to be a total independent body. I've explained it before that the judiciary, in accordance with the Constitution of South Africa, is supposed to be our own Vatican. It's supposed to be a total independent structure. It's not part of the state. It's not part of the republic. However, the state is supposed to fund the judiciary and also to protect the judiciary.
Right.
So in some way, the judiciary is now in such a state, in such a position whereby it's totally overshadowed and intimidated by the state to function in a way the state wants it to function.
Right.
I've done the calculations, Scott, that I don't have the figures with me now. I didn't expect to mention this now, but there are several cases. It's roughly in the hundreds, I believe, that I have ascertained in the Constitutional Court, which have gone missing. So when I say missing, it means that it has been issued, it has been proceeded with, but there is no judgment of whatsoever kind registered on their system. Coincidentally, our appeal that we have lodged against the government, there was a counter appeal that we have lodged for the declaration of the national state of disaster of the 15th of March 2020. We have gone up to the Constitutional Court with that matter, and we were so sure that our arguments were spot on. Then the Constitutional Court, nine odd judges, unanimously decided that we have no chance of success with an appeal, and that our appeal was dismissed. Now, come to that dismissal. It was never heard. It was never before the court. But the Constitutional Court today believes that it has got the authority to dismiss cases without any hearing whatsoever, and not even though the Constitution itself says that it must be heard, all matters before the Constitutional Court must be heard by a minimum of 8 judges. Heard. So there must be a hearing in terms of the Constitution. What they have done blatantly, I've disregarded the Constitution, and in several matters, in thousands and upon thousands of cases were simply dismissed without a hearing, where the Constitutional Court judges believe that they have got that right to override the Constitution. And so our judiciary has become an enemy of the people. Yeah. It has become an enemy of the state, and the state has become an enemy of the judiciary and of the people. So it's a total chaos out there.
Yeah.
People get excited when they say that let's take this matter to the Constitutional Court. Well, if you just know how difficult it is to get a hearing, an actual hearing in the Constitutional Court. If you do the maths, Scott, if there are 1,000 cases going to the Constitutional Court annually, but there's only 11 full-time judges with two acting judges. And for each and every one of those 1,000 cases, a minimum of 8 judges have to consider those cases.
Wow.
When you do the maths, you will just come to the conclusion that it is impossible.
Yeah.
And that those cases are being doorstopped by some establishment. We believe that it could be some sort of committee of some legal experts of some sort, which every week or so just sit and they decide whether a certain case must proceed to be heard, and there can only be roughly 15 cases which the Constitutional Court is able to hear in a year. So you do the maths that roughly 985 cases annually.
So that's 1.5% of cases that are put to the Constitutional Court are heard. 1.5%. Wow.
Yeah.
That's crap.
So, no, it's less, isn't it? No, you're correct. You're correct. So you must literally be some very important person to get your case actually heard before the Constitutional Court. So anyone who's actually saying, these people going to the Constitutional Court, let's give them hands up, it's not as good. And that is why we have Liberty Fighters Network has now established the practice that the moment when a case is dismissed by the Constitutional Court, we take it to the African Union now. And there it do appear at this point in time as if they are serious in actually addressing our cases. So we haven't had any any positive final judgment by the Commission, the African Commission yet, but they are actually attending to those matters. So,
Right.
but it's very sad, Scott, that we have reached a point where our judiciary in its entirety is so dysfunctional that there's no judges who are prepared to even stand up and say that let's stop this. The few that good ones that I know of have retired. They are not there anymore, and I'm talking about people, judges like Justice Rabi. I think Justice Tolme is also one of them who I believe is quite or was a very good judge. They just decided to pack up their stuff and leave, get their retirement package and go on with their lives. And unfortunately, it has reached a point whereby we need a total reformation of the entire legal system, and not only a transformation. We simply have to reform. We need to have a new constitution written by the people and not by the legal practitioners. The people must write a new constitution with our own court system. Otherwise, this is just going to get from bad to worse.
Yeah. Now, mate, before I respond to a few of the things you said, I just want to clarify. You've got a thunderstorm raging outside you, haven't you? Or is it your tummy?
No, it is a very nice thunderstorm, so it's not my tummy.
Well, there was just a discussion in the side chat, and some people thought it was my tummy, and so anyway, I thought I'd let you know. Look, I'm going to share an image with everybody watching, and I'll tell you what it is. It's the scales of justice totally out of whack. And this is justice in South Africa. This is what we're talking about, is that there is no justice in South Africa. And one of the things that struck me, Reyno, is that if you look at what's going on when it comes to the Chief Justice, I'm talking about Zondo, look at the Zondo Commission. Nothing has been done about all the allegations. Nothing. You know, they're still all walking around as if, you know, we're all above the law. Whereas you take Angelo Agrisi, the whistleblower, he's been arrested for alleged fraud and while all these top politicians are just walking around as if they've done nothing wrong. So the whole justice system in South Africa is cactus. I mean, there's supposed to be a separation of powers between law and politics, and there is no separation of powers. And I think of the fact that Julius Malema is on the committee that selects judges in South Africa. I mean, seriously? What does that say to you?
Yeah. No, I must be honest in that regard. From what I've actually seen him doing on the Judicial Service Commission is actually much better than all the others. He has criticized the judicial system very aggressively in those meetings. And yes, we might not like him, but he sometimes do ask the right questions, and it might be the same ones that we also want to have answers for. So unfortunately, it is so that the entire judicial system of South Africa has become look at, they are prosecuting me for contempt of court. I think it was now the 7th or the 8th time that I had to travel all the way from Pretoria to Bloemfontein to attend these court proceedings. So they want me to be prosecuted at the end. But yes, all the actual criminals are sitting out there those who are activists, those who are actually fighting the system against corruption, we are the ones going to be prosecuted and are being prosecuted, and eventually might even be jailed, and hopefully we will go to Robben Island, and after 27 years I might become the president of South Africa. So there is a very good positive thing about that, but it's not bringing us anywhere at this point in time.
Yeah. Now, look, I'm going to wrap up this live stream, but I just want to ask you this point. Could you update us on the current status of your legal proceedings, both in Bloemfontein Magistrates Court for Contempt of Court and the defamation claim in the High Court, Gauteng Division, Pretoria? And what are your expectations moving forward?
Okay, well, I've basically said that the defamation claim, that is about to be enrolled by myself any day. I will start those proceedings now. So that is where it is. The moment when a court date is set, I will definitely let everyone know. In connection with the contempt of court case, it has actually on the past a week or so back when I was there, it actually turned out to be very positive, in the sense that when I sat the morning on the 18th, me and my wife, she's always there to support me in this. It's only me and her always at court. But when I sat there and I worked through all my papers, I realized that the statement, the only statement that the state is relying on, that of Mr. Paul Myburgh, was not properly commissioned, in the sense that that Mr. Paul Myburgh indicated that he was a male, and then in the commissioning certification, the Commission of Oath indicated that the person who appeared before him was in fact a woman, a female. So that immediately makes the entire statement null and void. So I've raised that in court, and the magistrate, he was actually a very nice magistrate this time. He was he was smiling all the way when I was actually arguing. And he was also giving the state a lot of grief, because for the magistrate, it's also very entertaining to see how the Supreme Court of Appeal, which are supposed to be their superiors, are actually operating and what they are doing. So during this time, it came to the point whereby Mr. Myburgh was called as the witness, and I've immediately objected. I've said that, no, I object to have Mr. Paul Myburgh as a witness, because of the fact that his statement, which we are going to use as the basis for everything this case is based on, is null and void and not before the court. So that includes that all the evidence that they have already put before court can also not be used. So the magistrate, the advocate argued for the state, and he was very nervous when he did so. And the magistrate indicated that he agrees with me that this could result in this entire case against me to be also be dismissed. So unfortunately, the case is now postponed again until the 5th of April, I believe, yes, when judgment is expected from his side, whether the case is dismissed based on the fact that the statement which the state used against me is actually null and void, and whether that would make the entire proceedings against me null and void as well. So I'm very confident that the magistrate will most probably rule in my favor, but if he does not, we have made provision that the Monday and the Tuesday we will proceed with a hearing, and that the magistrate has confirmed that I am more than entitled to summon the deputy judge president and all any other judges that I would like to have before court as witnesses, to summon them. So it's going to be interesting if this case is not going to be finalized on the Friday the 5th of April, and that the moment when I'm going to continue, I will have Justice Meyer on the stand, who's going to be the first judge, and the Supreme Court of Appeal judges, the other 5, will definitely be summoned to court as well. They need to explain how they managed to make a judgment without hearing me, based on that I was apparently contentious. So it's going to turn out to be a very interesting trial that's lying ahead, and yeah, maybe on Friday the 5th I would technically or officially be free, and that they have to find another reason to criminally charge me.
Right. Now, look, I'm going to wrap up this live stream, Reyno, but look, it's a fascinating and disturbing story, because you get right down to the nitty gritty, and I've never been able to fault anything that you've said. So you must have these guys jumping on a hot tin roof at the moment, and it must be very, very hard for them. And of course, they are going to target you. I'm just going to put a message out to Marlena, who's watching. Marlena, can we organize to have, and this is obviously with your approval, Reyno, to have you back sort of in a date either closer to the time or just after the judgment, so we can talk about that?
Yes. No, we can definitely do so. Thank you. Thanks, Scott.
Alrighty. Fantastic. Reyno, look, have a great evening, and look, I'll be in touch and look forward to catching up with you later, as I say, probably around sometime over Easter. Take care, buddy.
Perfect. The same to you. Thank you very much.
Okay, mate.
Have a nice evening.
Okay. Bye for now.
Bye.
All right, guys, that was Reyno de Beer talking about the very, very inequitable justice system. Isn't that strange? Isn't that strange? Well, not strange when you think it's South Africa, let's face it. Now, I'm going to go out with the theme song Ons vir jou Suid-Afrika, which I know is one of the really popular ones, and Reyno's fighting for South Africa. Marlena, look, I'll leave that for Reyno, the specific date, but nearer the time, so he can give us an update on this huge hearing that he's got coming up with the SCA. Now, okay, what else did I want to say? Oh, yeah, that's right. Don't forget, tomorrow morning, 8 o'clock, I'm going live with Isaac van Zyl. Marlena, if you could perhaps just contact Isaac and just let him know. And I got information that Isaac has actually moved from Nailstrom to the family farm because his parents are very elderly, and his mother was looking after his father, but she is now suffering from macular degeneration and is pretty well blind. So, you know, macular degeneration is something that is very, very common among older people, and just be safe, guys. If you, as I said in that video this morning, if you see a bump when you're reading a book, you know how the words kind of look a bit bigger or they're a bit distorted in a particular part of your vision, that's called a bubble in your macula. And if you don't get a scene to, you could go blind. So just be aware of that. There is a special piece of paper. I've got it here somewhere. But what it is basically is lines going vertical and lines going horizontal, about the size of a, about the size of that. Okay, you can see my hand. So you've got the lines going up and down, they're about 5 millimeters apart. And what you do is you look at that, and you can draw this up, you can make it yourself, but it's got a special name with opticians. But if you look at that and you see any of those lines slightly distorted, it actually pinpoints that you have got macular degeneration. So you can actually create your own little checklist thing. As I say, it's lines going across about 5 millimeters apart, and then lines going down about 5 millimeters apart. And any distortion at all in that, when you look at it, means that you've got a problem. So just if you are concerned, just prepare one of those. As I say, it doesn't take long. It's about the size of that. And yeah, that's what I use as well, and it's very, very accurate. All right, I've burbled on enough. Guys, I'll see you 8 o'clock tomorrow morning with Isaac. And Marlena, if you can please call Isaac just to confirm that he'll be there. And then at 8:30, I'm going to be having Pietrasito joining us as well. And they will both be at Groblersdal, and they'll be live. And as I mentioned at the very start, the economic freedom fighters, yeah, that's good old Julius Malema, they are going to be there as well. In fact, they're gathering, as I said at the start, at Groblersdal Magistrate Court at 4 a.m. tomorrow morning. So this is heading for a really, really sinister outcome, especially when you consider what the economic freedom fighters are all about. So that's tomorrow morning. Now, wrapping up, guys, ons vir jou Suid-Afrika. Have a great evening. See you tomorrow morning. Bye for now.
Uit die blou van ons hemel, uit die diepte van ons see, hoor ons ver verlate vlaktes waar die kranse antwoord gee. Ons sal antwoord op jou roepstem, ons sal offer wat jy vraag. Ons sal lewe, ons sal sterwe, ons vir jou Suid-Afrika. Ek wil antwoord op jou roepstem, maar nie offer wat jy vraag. Das bloed op die plase van boere wat hulp vraag. S'nags hoor jy die sirenes, maar jy kyk ander pad. Niks daarvan op TV, net soms in die koerant. Das kieme in die water, Eskom gee beerdkrag. Riool stink in die strate, das oorlog wat wag. Gery maar op ons paaie, mense maak net wat hulle wil. Arm blankes in kampe, maar jy bly liever stil. Maar is 20 jare later en die beursies is leeg. Studente gooi met klippe en skole lê plat gevee.